Thank you, Honourable Member. This bill is of national importance. It was an act that was passed with the intention of modernising the legal framework for privacy and data governance, aligning Sri Lanka with global best practices, particularly with the European Union's General Data Protection Regulation. It was a forward-looking step. This was brought in 2022. But for 3 years, this bill has been dormant, and the core enforcement mechanism, which is the Data Protection Authority, was yet to be established. Now, if you look at it, basically, personal data protection is crucial for individual privacy as it safeguards against unauthorized access, misuse and disclosure of personal information. Currently in Sri Lanka, the question that we have to raise is whether that safeguard is available according to the prevailing act. Whether your amendment, the new act that the JVP government is bringing, whether it is dealing with these issues and whether the individual privacy is being safeguarded. That's the crucial thing. The UN, the United Nations Special Rapporteur on Privacy, in a 2024 report said, I quote, data subjects find themselves in a position of defenselessness owing to their limited knowledge of the use that third parties make of information concerning them, since in practice they are unable to follow up on these or to monitor this use. This has repercussions for their ability to control their data, the essence of the fundamental right to personal data protection. මූලික අයිතිවාසිකම් පිළිබඳ ගැටලුවක් ඇති වෙනවයි කියන එක එක්සත් ජාතීන්ගේ විශේෂ නියෝජිතයා මේ ගැන කියනවා. Now the problem is whether your amendments are dealing with this part. In April 2025 in Sri Lanka, this year there was a data breach. There was a cyber security breach, and this happened. This was reported in the Cargill's Bank in Sri Lanka. Hackers got through to the system, and there was a cyber security breach, and the hackers posted thousands of files, accounts of the bank, of personal data of account holders, directors, of the staff, etc. Now, this happened once in India also. In India it happened, and the Indian High Court took action to ensure that that data was protected. But in Sri Lanka, what happened? Cargill's reportedly informed about the unauthorized entry to their system through the Colombo Stock Exchange. Because they are listed in the market, they went through the stock exchange and just reported it to them. But no action was taken to inform the data subjects, that is their customers, whose accounts were breached. And it became public knowledge, it has been shared. The account holders, the public whose personal information was released, was not informed of what had happened and what security arrangements they should take and what would cause them, what were the losses that would have been caused to them. So does this act take consideration of breaches like that? That is the key thing, because it's our data. It will be mine, yours, all of us. Our data will be used there, right? And in the future, there will be other governments, there will be other people who will be looking at our data. In 2022, the enactment of the statute, when they brought it to this parliament, I think under the Jvpඅය Rajapaksa government, there was little attention paid because there was chaos in the country. There was COVID, there was bankruptcy. People were more worried about inflation and food and petroleum. So they didn't really look at this. Though there was a petition filed by the Young Journalists Association, the Supreme Court threw out that petition on a mere technical fault. So it was not taken up. Now this tension or confrontation between the state's right to information, because we believe the state has a right to information, yes, and this confrontation between the state's right to information and individual data privacy must be handled with sensitivity and care, because we need to preserve the democratic individual civic rights of people. Otherwise there would be a dictator regime that would come and misuse this data. So therefore, the Act has to address these things. That is why during Jvpඅය Rajapaksa's government, when the Act was brought, we got up and said there has to be amendments. And we believed that the JVP, which is a people's government, which is supposed to be a people's government, will be sensitive to the people's rights. But I don't see that in the amendment. That's the issue. Now, amongst many shortcomings of the Personal Data Protection Act, there is a lack of, as this was described very well by a young researcher in the Daily FT, she has put it, I quote, amongst many, she's Nida Admani, she says, amongst many shortcomings of the Personal Data Protection Act, the lack of clarity and inaccessibility by the average citizen to fully comprehend the rights and remedies available under the Act. The power imbalance heavily favors data controllers and processors, and citizens are unaware of how their data is being used. So that leaves people vulnerable. Now, data usage can infringe on ethnicity, on religion, on race, on a lot of things, and data can be misused. In the European Union and in the United Kingdom, they classify special categories of data that could cause significant risk to individuals' fundamental rights. So basically, on this bill, Honourable Member, this bill is of a national importance, but there are glaring deficiencies in the framework, and your amendment, the government's amendment, does not get close to even addressing them. And this is shocking to come from the JVP, because when you all were in opposition, when you all were seated on this side, when the President, Honourable Anurakumara Disanayaka, Honourable Vijitha Herath and Honourable Harini Amarasuriya sat on this side and vehemently condemned this bill and said there should be certain amendments. Here is the opportunity to bring the amendments, but you have not incorporated it. So, if you look at the Data Protection Act in the appointments, one of the main things, if you take the constitutional count, if you take the appointments to the Data Protection Authority, the Data Protection Authority which is going to be appointed, you would appoint technocrats, business leaders, industry representatives, because they will all be dealing with data and they'll have to be special engineers who know that knowledge. But what about the appointment of a human rights lawyer, about an independent person, a civil society specialist who can be appointed into this? Now, all these appointments will be political appointments, because we made an appeal at that time, we made a request, we made a demand. When we were in opposition, we still take that position to say that the Data Protection Authority must be appointed through the Constitutional Council, because that will ensure independence of the Data Protection Authority. Otherwise, if you just make it a political appointment, if the President is going to appoint this authority, then where is the safeguard for the privacy of the citizens of this country? I cannot see how the JVP can change that position, because that is not something we can understand. Second, this act, when you look at this act, it grants broad exemptions to the public sector. The public sector or the public entities, in the name of, for example, in the name of national security, they can use data, misuse data, collect data, and they can abuse it. Now, for example, if it's a national health sector, if there's some very sensitive private information about people that they have collected, and if there is a breach and if that data gets out, it could harm the dignity of a lot of people, of their private lives, and that's not fair. But public entities can go about without answering any of those questions. For example, even the Defence Ministry. In the Defence Ministry, if there is a breach, then the Defence Ministry must be subject to certain rules and regulations, because if they make a breach, they should disclose that to the public, so that the public is aware that something like that has happened. But the Act doesn't take care of that. So if we are committed to protecting privacy, then the government must be subject to the same standards as the private sector, if not a higher standard. Next, if you see, again, the Act falls short in empowering certain categories. It does not grant a right to erasure or data portability, or the right to challenge decisions made by algorithms. Because in today's AI-driven world, these omissions can be more than technical. They can become political. But the act that you have brought in does not address these issues. Next, even so, in this Act, on the other side, there is no tribunal or a civil appeal system to enforce or have a mechanism to make sure the citizens can be safeguarded. The citizens must rely solely on the Data Protection Authority. Now, the Data Protection Authority is not appointed by the Constitutional Council, it is not independent, it is appointed by the government at that time. This government might be here this year, next year there might be another government, right? So then the other government, which I think will happen, the other government might use it in a different way. But if you have an independent committee, whichever government that comes, on a day the JVP sits in opposition, you will have to talk another language. But we believe in talking the same language whether we sit on the opposition benches or on the government benches. Because what is right is right. You can't change that. So therefore, we think that this amendment has to encompass certain changes. We believe we are proposing that there must be parliamentary oversight. We believe that there must be amendment, the exemption clause to include judicial or parliamentary oversight for government access to personal data. So Parliament has oversight over it, to establish a data protection tribunal to handle complaints and appeals, and the Data Protection Authority that it should be appointed through the Constitutional Council to ensure its independence, and that representation from legal and civil rights specialists must be included in that group. ගරු
මන්ත්‍රීතුමා තව විනාඩි දෙකක් කාලයක් තිබෙනවා.
මම විනාඩියකින් ඉවර කරන්න මන්ත්‍රීතුමිය. මම මේ ගැන විශේෂයෙන්ම මේකේ තාක්ෂණික පැත්ත කතා කෙරුවා. මොකද මේක තාක්ෂණික විෂයක් නෙවෙයි. මීට වඩා අපේ ප්‍රජාතන්ත්‍රවාදී අයිතිවාසිකම් පිළිබඳව. එක රජයක් දවසක රජයේ ඉන්න පුළුවන්, ඊළඟ පාර විපක්ෂයේ ඉන්න පුළුවන්. අපි විපක්ෂයට එනකොට අපිට තේරෙනවා සමහර විට අපේ අයිතිවාසිකම් උල්ලංඝනය වෙනකොට ඒක බරපතල විදියට අපේ රටේ ජනතාවට බලපාන හැටි. දැන් ජනතා විමුක්ති පෙරමුණ දැන් අවුරුද්දකට කලින් විපක්ෂයේ වාඩි වෙලා හිටියා. ජනතා විමුක්ති පෙරමුණ 2022 මේ පනත ඉදිරිපත් කරනකොට මේකට විරුද්ධව මේ පනතේ සංශෝධන කීපයක් යෝජනා කරා. විශේෂයෙන්ම Data Protection Authority එක අනිවාර්යෙන්ම ස්වාධීන විය යුතුයි. එය ව්‍යවස්ථා මණ්ඩලය හරහා පත්විය යුතුයි කියලා හරයෙන්ම මෙතන තර්ක කරා. හැබැයි ඒකම අද මේ රජයම එතෙන්ට ඇවිල්ලා ඕක නොකරනවා නම් මේක පුදුමයි. මේක ඔබ හැම දෙයක්ම බලයට එන්න කලින් ජනතාවට කියපු දෙයි දැන් බලයට ආවට පස්සේ කරනේවා ගැන බලනකොට මේක සාධාරණ නෑ. ඔබට මේ ස්ථාවරය ගන්නවා කියන්නේ මේක බරපතල විදියට අපට අපේ රටේ ජනතාවගේ අයිතිවාසිකම් වලට හානි වෙනවා, බලපෑම් වෙනවායි කියන එක මම මේ සභාවේ කියන්න ඕනේ. ඉතින් මට සමහර විට හිතෙනවා කලින් ආත්මයේ JVP එකේ හිටපු අය සර්කස් කාර්යෝද දන්නේ නෑ. මොකද ආලා හරි දක්ෂයි බල්ටි ගන්න, කර්ණම් ගන්න. එක දවසක් එක පැත්තක් ඊළඟ පාස බල්ටි ගන්නවා වෙන පැත්තකට. ඒ නිසා තමයි මං හිතුවේ මේක වැඩි පිරිසක් ඉන්නේ සර්කස් කාර්යෝ කලින් ආත්මයේ කියලා. මේක ඒ නිසා ඔබ විපක්ෂයේ යෝජනා කරපු ඒ පුරවැසි අයිතිවාසිකම් වෙනුවෙන් දැනුත් පෙනී සිටිය යුතුයි. ඒ සංශෝධන ටික ගේන්න අපි තතෝසොල දෙන්නම් ඒක සම්මත කරන්න. ස්තුතියි.
ගරු නන්දන